Anyway, now let's move on to the issues we have tabled for discussion this morning. And of course, we are starting from the court. And as you know, the Electoral Commission now, I don't know how it's actually getting out of all of that. It has just too many suits on its hands, and yet it is required by law to have given a clearest indication, the clearest indication of elections in December 7 by a certain notice, which is still not available. How many days do we have to the elections? And thankfully, it does look like the Supreme Court on Monday will make a decision that may, help the situation a bit, but doesn't appear to be an absolute cure to what we are in now. Now everybody is afraid. Let's begin with the victory that Hassan Yarga had yesterday, which was just like that of Dr. Papakwesi Indum. And some are already projecting that all the other cases in the high courts, including Dr. Edward Mahama, Dr. Edward Mahama has a human rights approach to his challenge. And the lawyers were in court. Dr. Raymond Atuguba argued in a way that you cannot get any better advocacy than that. Well, the AC's lawyer, Tadio Sori, was there and gave his opposition, which it's become an opposition that we are too familiar with. Then you have Nana Konedo Ajman Rawlings. Her case, the EC had filed to ask the judge to recuse himself because they felt that he will be biased in the process because he's made determinations already on the matter as regards the Indum matter. The case was heard in the afternoon. The Tadio Sori and Asan Kuma, great friends, great minds, engaged in a tussle there. In the end, the judge ruled that the EC should get off, and that the judge is able to deal with the matter on its merits and as a separate issue. As you know, IPP's Kofi Apalu is also in the High Court, and his matter too will be heard sometime in the week. Once again, I start with Kweku, and there are several other issues about the EC that we will bring in this regard. How do you see the matters going forward? Do you think, like other people are saying, that this matter, all the other matters that are pending, will go just in the same way as what has happened to Indum and Hassan Ayarga? And in Hassan Ayarga's judgment, a portion where the judge said, page 12, the judge says, I am of the view that for the nomination period to be meaningful, it should be a period within which all the requirements for the nomination of a candidate, including submission of nomination papers, statutory declaration, payment of deposit, notification of anomalies found, and provision of opportunity to correct anomalies can reasonably be done. She took refuge in what her brother, Justice Sheba, had to do in the Indum case and came to the conclusion that the EC's act was unfair and therefore Hassan Yanga should be given the opportunity.
Well, you are asking an unlearned mind to initiate discussions.
That's good.
Well, we have two lawyers here, but that's fair deal.
Right.
It's okay.
Oh, yeah.
Listen.
Who is in good company?
I have to be honest, and I'm talking as a non-lawyer, somebody on the streets. I'm beginning, and I may be wrong, the lawyers are here, they'll cure my mischief. I'm beginning to think that there's something out there, some attempt to legalize absurdity. I'm beginning to think that we are dealing with a certain legalized absurdity in this whole thing. And that's why I'm happy that somehow the matter has gone upstairs. Last week I wasn't with that mind. I thought there shouldn't be any protracted litigation. I thought we should truncate things. But suddenly I'm beginning to think that that earlier position was wrong because of the apparent domino effect that the earlier High Court ruling appears to be having. And I can see in my mind's eye that it could happen with the Edward Mahama case as well. It could happen, look, perhaps even the Kuyadonko, could go there and ask for extension in order to be given the opportunity to cure whatever errors were in her thing. Okay, because Ayariga, if I recollect, if I'm wrong, you can correct me quickly, that was given an opportunity to actually correct 30 errors.
That's right.
He had as many as 30 errors.
The judge
In addition to
refers
these
that.
two.
Yes. The judge refers to that, and I just wanted to go to that paragraph and read. But there was an issue she disagreed in the manner the EC did it. It says that.
Yeah.
It says that this paragraph, page 10, it says that the ground on which the applicant, that's Ayariga, was disqualified was that the commission, upon scrutinizing his nomination papers, discovered that 2 people who subscribed to his nomination form had also subscribed to the nomination forms of other candidates. These were not the only errors that were found on the applicant's nomination papers. 30 errors were discovered when he submitted his nomination paper on the 29th of September 2016, but he was notified of them and given the opportunity to amend them in accordance with the law. The reason assigned by the Commission for not notifying him of the 2 other errors based upon which he was disqualified was that they were not detected within the nomination period. And the judge continues to say, counsel for the Commission explained that the 2 errors were discovered after the nomination period had closed on 30th of September 2016, and as a result, the Commission no longer had an obligation under law to notify Ayariga of the same. Then she says, taking on its face value, this argument sounds logical. The law stated that the Commission was to inform candidates that their nomination was invalid where they detected anomalies in their nomination papers, and to give them opportunity to amend them within the nomination period. Therefore, if an anomaly slipped detection within the nomination period, or if it was the kind that no matter the level of scrutiny applied to it within the nomination period could simply not be detected, the candidate will be disqualified. In my view, such an approach may be justified in an ideal situation. In the present case, however, things were far from perfect. This is because a careful reading of the law shows that all things being equal, the candidates should have submitted their nomination papers, statutory declaration, paid their deposits on the same day. However, a court case, blah, blah, blah. And
yes, so she stretched the nomination, the period that, the end of it to the receipt of nomination fees.
Exactly. I wanted to reach to that point, but it's a bit lengthy.
Yes, but I got a drift all right. You know, so that's the situation. And that could easily apply to all the rest. I'm telling you.
Yes.
A chain effect. I mean, domino effect.
Yeah.
And that's why in my uneducated, unlearned mind, I think what we are doing here is dealing with the legalized absurdity. And I'm worried. We might as well then open the floodgates for all these 12 disqualified people to join the 4. And so we can have a huge ballot box there.
Ballot paper.
Paper out there. We might as well do that. But you see, thankfully, the case is gone to the Supreme Court.
Right.
And I kept on always saying that why I was interested, thinking that mischief could have been cured at the High Court level, was for us to determine what kind of error can you even be allowed to cure. You see, these the 2 that were left for Ayariga obviously could only have been detected after you've gone into the database. The nature. They are not things that on the face value of the documentation you could see, so that the person could be offered the opportunity to cure. Those things are done when you do cross-checking, dealing with the technical, the ICT thing. Then it pops up. So I don't know, perhaps this litigation, some people are worried, some people think it will derail the processes. I don't believe so. I'm confident that we're going to have the elections on December 7th. I don't believe in all those doomsday scenarios. It's legitimate to raise the questions. I realize Akoto Ampao, my own good friend, has raised some issues. Good questions, but they are not questions that are unsurmountable. The challenges that the questions pose are not unsurmountable. And many of those answers could be provided on the IPAC level, in my candid opinion, rather than subjected to litigation in the courts.
Let's hear some of the questions that Mr. Akoto Ampao has raised. He's actually written a letter to the Electoral Commission asking a set of questions and demanding answers as quickly as possible to put our anxieties at bay. Let's hear Mr. Akoto Ampao.
Therefore, it ought to act with wisdom and sound judgment such that it is ready for elections on the 7th of December. What do I mean by that? Just is it today, in the NDP, is it NDP, National Democratic Party?
Yeah, they were in court.
Nana Kunedu's, I think.
Yeah, they were in court.
They had filed a process
Yeah.
for the EC decision to be quashed. What did the EC do? Instead of addressing the substantive matter, they brought an application, which was argued today, saying that the judge should recuse himself and so on. I'm saying that if the EC is concerned to deal with these things expeditiously, it should avoid technicalities. Because that application has been thrown out, but because that application was brought, it's been thrown out, another date has to be fixed for the substantive application to be heard. So I'm saying that the posture of the EC, its judgment, should tell us whether it is seriously working towards the resolution of these legal disputes before 7th December.
You're welcome back. Among the questions that Akoto Ampao is asking is, in the Commission's considered judgment, and all things being equal, when does the Commission project that the current spate of lawsuits involving it and those presidential aspirants whom the Commission has disqualified for stated reasons will end to enable the Commission carry out the ballot for positions of the presidential candidates on the ballot paper? 2. When in the Commission's considered judgment will the ballot papers for the presidential candidates for the 2016 elections be printed and ready for the December elections? Are there other election materials, such as a statement of poll for office of Member of Parliament and statement of poll for office of President, popularly referred to as pink sheets, the certificate to be endorsed on the rates, and the certificate to be endorsed on the rates, 2 different forms for them, for the presidential elections, and the parliamentary election results collation form, and the presidential election results collation form, 2 different forms of them, already printed out and ready for use for the December elections? If they are already printed out, when were they so printed? If these materials have not already been printed out, when in the judgment of the Commission will they be printed out and be in the custody of the Commission to ensure the conduct of general elections in December 7? Will these election materials be printed in Ghana or abroad? Finally, question 7. When in the judgment of the Commission would be the last date that it should have concluded the current lawsuits it is involved in as a party and should have printed all relevant election materials as set out above to ensure that it is able to conduct and supervise the December 2016 presidential elections?
Some very legitimate questions to raise, but some of those questions are clearly outside the remit of the EC now because of the litigation. And I hope my memory is not deceiving me. I thought I heard the EC suggesting that they've given the Supreme Court all the timelines and things.
You heard it right.
Yes. So it means that the judiciary will be minded, and so some of those questions ought to be dealt with relative to the litigation going on, and I believe the judges will know what to do. Some other questions can easily be dealt with at the IPAC level, and indeed some of the processes are ongoing as far as I'm told. Look, no printing of ballot papers or things will be done without party agents being represented. at those places. Am I right?
Right.
They do that.
Yeah, they'll be there. It will be done. They will have to put their seals on some
all
of the
those things.
processes.
Yes,
yeah.
I think we are still within range. These are good questions, but some of them can be provided at the IPAC level. I'm not suggesting for a moment that the EC cannot give the answers publicly. They give some publicly all the time, but the critical ones are within the realm of the court, and we should let the courts decide on those things.
Interesting. Yeah, just quickly on the Ayarga issue, then dovetail it into the broader subject that is being discussed. What the judge asked, and Kweku is suggesting that it would have a domino effect. In fact, I've heard somebody like Amalba say that he can predict all the other cases, with the exception of what is in the Supreme Court. He can predict that they will all go this way. Now, the judge asked the question that you say you couldn't alert Ayarga to make the corrections, the 2 other corrections, because you detected them after the nomination date. And the judge says, whose job is it to detect the errors and to call the people to make the corrections? So if you detected it after the time had elapsed, who is to blame? And in any case, you have heard them suggest in other suits that these are not matters we should be calling you to come and correct because they border on crime. The judge said, Ayarga actually, after he made the 30 corrections, and his attention was drawn to this through the EC's press conference, he took 2 other names there and said, substitute these 2 names, and he was denied. Do you also share that view, coming from a position of a lawyer, that the other cases are likely to go this way, and perhaps it is a waste of time to pursue them?
Let me, first of all, now that we are starting formally, say hello to Adenta constituency. The initial remarks were initial. No, a grave one. And then I also want to give a shout out to the Mamprogo Youth Network, who have come together to campaign for Nanado and Dr. Baumia. It's very important that we recognize those who are doing the work in the field. 2.5 weeks ago, I had occasion to make remarks about the state of the EC, its preparedness, and these lawsuits. The bottom line, the question that is being asked here, is that in the event of administrative and operational failure, who deals with it? In the context of the constitutional provisions protecting the EC from operational interference. The Constitution almost sets the institution up to be infallible. But we have realized over years that they are human and they can fail. And that is why IPAC was brought in. But the Constitution, the Commission has also insisted over the years that in spite of IPAC, they have a right to their own thinking, and that IPAC would only be advisory, and that they would only consult IPAC to the extent that they feel they cannot resolve a matter. Here we are. Can we accept the Commissioner's assurances of delivering an election on the 7th December, when Kweku, who is an incurable optimist, is here saying that some of the issues are out of their hands? If the issues are out of their hands, then it jeopardizes their promises to us. Suppose they don't meet their commitments to us. What happens? So 2.5 weeks ago, when I'm completely in sync with my senior counsel, when he says these things, I raised that matter. And I said, probably what should be happening is that the decision, the first decision, should have been taken in rem. And you understand what I'm saying? That the first judge should have reviewed the matter and given a decision to impact the rest. Because it is possible. We were all suffering from various shades of the same malady. At the time the first case was sent to court, it hadn't even been decided. When I first made those remarks, they had just gone to court and it had yet to be decided. So I made the observation that if it decided in that singular case alone, as we lawyers say, in persona, then what would happen is that the others would troop to court. And that would take December 7th out of the hands of the Commission. It will make the Commission's promises to us about December 7th very, very unlikely, because they have no control over the litigation process. It doesn't matter that the courts would want to expedite matters. Technicalities are still there. And you can't stop a person who is litigating from going through the technicalities. But they take time. They take time. And so, if the courts are not prepared to decide in rem, which is to impact everybody else, so that we cut this matter. And I don't mind whether they say they should disqualify everybody or they should go ahead and disqualify everybody. The question is that we would have a cessation of the difficulties we have now, and we can focus on seeing whether the time that we have left can deliver us an election on December 7th. I want us to adopt a proactive approach. It's not a doomsday approach. I think by this time, we should begin to think about the potential scenarios in the event December 7th does not deliver an election. And we have to add some more questions to...
In the event December 7th does not deliver an election.
And we have to add at least one or two more questions to the list that Akoto Ampah has so kindly furnished Ghana. Can the parliamentary election be held alone, earlier and separately from the presidential election?
No.
Thank you. So if we are still in court and we are printing ballot papers for the parliamentary, we are running full speed, we'll get to the point where we are ready to run a parliamentary election, but because of the presidential one, we are unable to have an election. So what happens?
They are faced with a reality. I don't understand it. They are faced with a reality.
Yes.
And because of that, they are making preparation for all other things.
Sure. That's what I'm saying.
Waiting for the single one that is still pending.
Yeah,
so that
but
when that is
easier dealing with
dealt
that
with,
challenge.
then they will do that. And
But
you
what
have a
about
problem with that?
Yes. No, I don't have a problem with that.
Okay.
I have a problem with those who are waiting to go. Because, like he said, Ekweadonko has a right to go. They are waiting to see what happens. They may go. If they go, it will be, yes, another one in the queue we are waiting for. Then she finishes and an independent goes. And there's another one in the queue we are waiting for. So we could have that queue and it will be an interminable queue. That is sitting there.
Not have an effect of maybe truncating some of those litigations?
If the Supreme Court pronounces at large, that's what I said in rem.
Okay.
In law, we have in personam and in rem.
I hear you.
The Supreme Court pronounces a decision that affects everybody else with various symptoms of that kind of malady, then they are compelled to follow that ruling. Then we don't have them waiting in a queue. But I believe that we should begin to think about what happens. And I have gone ahead to look at a few things. Because I believe that in this case, the president's powers of emergency does not apply. The administrative failure will not qualify for the use of the president's powers to extend his rule. I looked at a couple of provisions in the Constitution, and 63(2). Something, you allow me?
Go ahead, let's go. 63(2). What does it say?
63(2). Article 63(2). In fact, the entire 63(2), I'll read A and B. It says, the election by instrument prescribed by the Electoral Commission and shall be held so as to begin A, where a president is in office, not earlier than 4 months, nor later than 1 month before his term of office expires. So it means December 7th is the constitutional deadline. Then he goes on to say, B, for me, is the B that we must begin to deal with and interrogate. In any other case, within 3 months after the office of president becomes vacant. In any other case, within 3 months after the office becomes vacant. So that whatever happens, the office will become vacant after 4 years. But I found something very interesting reading the public regulations, CI 94, section 16 of which says adjournment of poll. Look at adjournment of poll. It says, 61, the commission may, at any time between the issue of a writ, which hasn't been issued yet, you mentioned that, and also has a timeline, 30 days. So that one is also an issue for questioning. The issue of a writ and the day specified in the writ as polling day, adjourn the taking of the poll for a period of not more than 30 days after the day specified earlier. It doesn't say it has to give reasons for the adjournment. The commission shall, the 2 gives the reasons. The commission shall specify the reasons for the adjournment in the notice of adjournment and publish it in the Gazette Where a notice is published in the Gazette, the rate for the constituency to which the notice relates shall be considered as amended by the substitution of the day to which the taking of the poll is adjourned. But here, 3 says constituency. So then I begin to worry. Does that mean that it is only a parliamentary election, single constituency election, that can be adjourned at the instance of the commission for stated reason, or we consider the presidential as one constituency?
Whatever adjournment it is subject to the constitutional deadline.
Yes. Exactly. So that means that what will happen is that we will have a crisis where the president has to step down. If it's adjourned for not more than 3 months, it will mean that on January 7th, midnight of January 6th into 7th, the president steps down. And that means that in the absence of the president, the vice president, and of course a speaker, because parliament would have been dissolved, then the chief justice may have to act
Parliament could extend its life.
I didn't say so here. That's the question. With reference to elections, that is where I'm saying that we must begin to be proactive.
You are inviting us to interrogate hypotheses.
No.
Very far-fetched. Yeah, that's why you are inviting us. I appreciate it, but I'm unable to accept the invitation.
Today is the 5th November. Printing of pink sheets has been awarded to a company that we don't even know has facilities in Ghana.
That doesn't mean it cannot be printed.
Please.
But the last time, where were the pink sheets printed?
We'll deal with that separately briefly. So let's move on.
You see, there are issues.
But they were printed outside.
There are issues. The issues.
2012 pink sheets were printed outside.
The other question that has to be added to the list of questions that it's not just the printing of the materials, it's also the distribution of the materials.
Okay.
Which doesn't take
the work that is supposed to be done in the time that we have, by the 1st of December, for example, the printing, the distribution, the location of officials, all ought to have been done. Because when you take off for special voting, you are actually voting.
Okay.
You understand?
All
So
right.
I am of the group who believe that we must begin to think through those scenarios. And it doesn't hurt. You must have a plan A, B, C, particularly where the provisions are not clear on the face of it. What to me is very clear on the face of this constitution is that in case of any other happening, the office will be vacant.
Okay.
By 7th.
Right. Toku says
January
the hypothesis he had tweeting all of us.
It's a rather bizarre hypothesis. Again, I'm unable to appreciate where that fits into the whole discussion. I find some of the narrative rather troubling. It does appear to me that it is being argued that the constraint of time makes a compelling case for glaring faults and irregularities to be overlooked. I find it most troubling. Yes, but that is essentially what we are saying here. You see, we have an institution that is charged with the responsibility of conducting elections. Through various processes, they have established...
So if you're correcting, he will argue better. He's saying that I'm saying it should be glossed over.
I'm not saying... No, I'm not attributing narrative to
He's
you.
not talking about
I'm not attributing narrative to you. My difficulty was with your hypothesis
about the problems with the EC going to court.
Exactly. We have a body that is charged with the mandate of organizing elections. They have to operate within a certain set of rules. All players who seek to partake in that game are enjoined to play by the rules. So they set a date for nominations and a period within which you are supposed to do the nomination and present same for the process to continue. They scrutinize the various nomination forms and detect irregularities that, in their view, makes the candidacy of the affected parties untenable. The question to ask is whether or not they have acted within the law, or rather whether or not they should, because of concerns expressed by others about timelines.
At least we know that 2 courts have expressed that they were not acting within the law.
But again, the EC could not have made that determination without conforming to their own regulations. Or at best, they thought that what they were doing was within the law, and they are entitled to do so. It is another body that has determined otherwise. And the EC cannot be faulted for the decision that they took. It's a legal argument. The point is that I am the organizer of elections. I set the rules. And I say that you must play by these rules. You present your forms. I scrutinize them and find that there are things that make your candidacy, at least to my understanding, untenable and unlawful. So I throw you out of the game. And you go to court. It is not the EC's fault that the parties so affected decided to go to court. It was a choice that they made.
And the court restores them.
Great. The court restores them.
Martin Abidu thinks otherwise. He says this is arrogance and...
No, but how is it arrogance?
And lack of good judgment.
No,
Exercise
how
of good
is
judgment.
it arrogance?
He says this was
How
so
is it
simple
arrogance?
for
You
the
see,
EC to have known
how
from
is it
the start.
arrogance? Especially when the EC itself has also challenged the ruling of one of the courts. It is entirely possible that a higher court can overturn the decision of the lower court.
That's why they are
If that happens, absolutely. So why do we then conclude that merely because a high court has disagreed with the EC and ordered them to give opportunity for some amendments to be made to the nomination form, then the EC acted so unlawfully that there's no remedy? I think that we should wait for the Supreme Court to pronounce their pronouncement, and I share that view.
Time runs.
No problem. Mind you, the judiciary itself has indicated its readiness to
It's
expeditiously
not about
deal
a
with
high
these
court,
matters.
it's about high courts.
High courts.
For
Fine.
example, in three different courts, they have gone to raise technical legal issues,
Which have been
saying
upheld.
that you can't come by this way. In all three, the court says, get off.
Fine. But there's also one case that has prompted the EC to go to the Supreme Court for some determination to be made, which would affect the process in the event that they secure victory. The point I'm making is that to say that somebody has gone to court and so the EC has done wrong and that we are not going to meet the deadlines is, for me, untenable. That's a position that I've taken on this particular matter. I also do not believe that the EC should be disabled from carrying out their functions merely because of the threat of court actions. I also get the impression that people have resolved to use these happenings to further undermine the position of the Electoral Commission and make it seem that they are not in a position to run this election. Elections are informed by many processes and stages. As we speak, part of the processes are ongoing, with the printing of ballot papers for parliamentary elections and the printing of the statement of roll or statement of polls, which is also a matter that is in contention, but I'm sure it will be resolved. I also do not see any reason why we should say that December 7th cannot come off because of these litigations. We must empower state institutions to enforce laws, enforce regulations, enforce standards. If people come to the game and they clearly fall short of the requirements, they should not be allowed merely because of the constraints of time. And for me, that is a central argument that those who seem to be opposed to the EC are making. By all means, let those who are affected seek redress on other platforms. But let us not say that the EC should not apply the laws, at least as far as they understand it. That, for me, is at the center of this particular matter. But as for YB's arguments about constitutionality and deadlines and whether or not the president will be in power beyond December 7th, I think that it is completely irrelevant.
Matamidu says it's a question of common sense that he feels is lacking. And you have, when Dr. Edward Mohammed's case was being argued, Dr. Raymond Atuguba, for example, the technical issues that Mr. Akoto Ampao feels ought not be engaged in, Dr. Raymond Atuguba was demonstrating to the court that for 2 decades in this country, that argument brought before the court have been thrown out. The EC has brought them up for 2 decades now, and they've been thrown out. So he feels that it is terrible to come to the court to be making those same arguments, which consistently have been thrown out. He makes the argument that when they throw Edward Mahama out, they simply do not make some basic enquiries into his processes, and that if they were minded to have done so, they would have realized that the decision they took was wrong. Don't you think all of that feed into the questions that are being raised about the judgment of the EC in these matters?
You see, let us come back to the heart of the matter. The heart of the matter is that the EC, upon scrutinizing the forms presented to it by a number of parties, came to a conclusion that those parties have acted in ways that violate their regulations and therefore are not qualified to be allowed to contest the elections. That was a fundamental issue. Now, those who are affected by this have gone to courts. Courts have made pronouncements and upheld some of the claims that the applicants took to court. I am saying that to the extent that courts themselves can err, and there's a possibility for earlier decisions to be overturned by higher bodies, it is not fair to conclude that by not allowing those people to get onto the the electoral system, the EC had undertaken such a fundamental error that the elections are in jeopardy.
Okay.
Especially when the judiciary has indicated a willingness to dispose of these matters quickly. And by their record, they've kept to their word.
Yeah, they've done that.
Quickly, within a matter of days, they've dealt with the issues.
Yeah.
And we are seeing our way clear in this particular matter. I also do not believe that the processes that are outstanding are such that they cannot be undertaken within the time left for the elections to be held. I am yet to be convinced, or better still, I'm yet to hear a compelling case that this election
You don't have any fears
I don't
about
have any, because I have been involved in election process
The
before.
EC itself has its fears. You don't.
Well, I don't. I have been involved in elections before. Printing of materials and distribution of same does not take forever. In a matter of days, it is done and can be done. And I think we still have enough time, especially because of the posture and attitude of the judiciary, to settle these matters quickly.
Okay.
And see our way clear.
Let me bring Clara in here on one point before I can see that you have notes that you want to deal with.
Yes.
Is he, like the Electoral Commission chair has told the BBC, that she's convinced that because they've given their timelines and everything to the courts, she's sure that things will happen on December 7th. Everything is on course. Are those assurances properly founded? When you hear suggestions from people like Akoto Ampah, that the matter before the Supreme Court may not, and he just also suggested, may not end the litigation entirely. You have gone to say the way they came to the court was wrong. They should have come by petition rather than by judicial review or by human rights enforcement. The lower courts, the high courts say you are wrong. And you have gone to the Supreme Court for a determination. What it means technically is that if the Supreme Court holds that they went by a wrong process, it simply means you can go back, but through another process, and the litigation will continue.
Yes, that is a hypothetical situation. But like Kweku said, I am very confident that the cases in the courts are not going to affect December 7th. We have to admit that there is no injunction on the holding of the elections. No court in this country has placed an injunction on the holding of the elections on the December 7th. And we should also know that the only legal way that could affect is if somebody secured an injunction. But we know the grounds for the grant of an injunction. One of them is the balance of convenience. We have a constitutional requirement that must be met. Otherwise, we are running into a constitutional crisis. So I think that using the litigation as a basis for fear that the elections wouldn't come on is unfounded. As to whether or not the assurances are insufficient, it's a different issue. In this situation, I don't think that assurances are not enough. There has to be more than assurances. The people need to see that the EC is committed to its timelines, that the EC is doing everything possible to make sure that there is no hitch on the election day. I think that will be a more concrete assurance to the people that we are ready for the elections.
The EC based her assurance on the assurance of the Chief Justice.
Which is a weighty assurance.
Which is, the Chief Justice has demonstrated, I think, beyond reasonable doubt, that the judiciary is prepared. I have absolute confidence in the judiciary, and they have demonstrated it. In their case, it is not just assurance. They have demonstrated their commitment. So we have no basis to be afraid. We have no basis to be afraid, and I have a caveat there because of the litigation. It has nothing to do with it. If we have other concerns, that is a different issue, but it has nothing to do with the cases in court. And I must add that the cases in court are important. It is extremely important that those cases were brought. So I actually commend all of the people, all of the parties who have brought cases in court. It is important for us to be able to consolidate our democracy, one, and to hold institutions that we have given power for our welfare and for our benefit in check. I'm not going to comment on the case before the Supreme Court, but I will comment on the cases that have been determined on by the High Court. I think if you look at the cases that were in court, they border on two things. One, natural justice, and then the obligations of the EC under CI 94, particularly, or one of them being Regulation 9.
Right.
I think think the case for me, if you look at the situations, is straightforward. But even before I come to Regulation 9, let's look at the role of the EC in this, stemming from our Constitution. If you look at the preamble of our Constitution, it is very clear the constitutional values that we as Ghanaians aspire to or want to keep. Most important, let me just read it briefly. It says that in the exercise, we, the people of Ghana, in the exercise of our natural and inalienable right to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity. Anybody who is, any institution that is set up under the Constitution cannot ignore the statement. It tells you what we want, which is liberty, equality of opportunity, and prosperity. We go further to Article 23, which says that if you've been given administrative power, you must exercise it in a certain way. It must be fair. It must not be arbitrary. It must not be capricious. The reason is for us to be able to ensure that if we give you power as a body, you must exercise that power for our welfare and treat us equally and equitably. You cannot use that power to, let me say, probably help the people you like or respect and then disrespect or affect the people that you don't like. So the EC had an obligation under the Constitution to treat all the political parties equally, because the principle or the value, what I would call the spirit, is equality of opportunity for everybody. So when it comes to this, let's not go on who we approve and we disapprove. There is a Constitution, we have rights, we have to abide by them. Now let's come back to the obligations of this EC with respect to the nominations and how they deal with the candidate. If you look at Regulation 9, it is very clear. It is very clear. I think it is very clear, and there's no ambiguity in Regulation 9. Once a candidate submits or delivers their nomination paper, they stand nominated. What it means is that they then become a nominee. Unless it gives the only caveat for when they cannot be considered nominee, which is that you must provide proof. And I place emphasis and importance on the word proof, because proof is not equivalent to rumor or suspicion or feeling.
Or speculation.
It has to be proof that the EC must have been giving proof of death, not rumor of death, proof of withdrawal or proof of disqualification. I would want to read proof of disqualification to mean that you have been disqualified under Article 66, for example, the requirements that are set there. And now let's look at the obligation. After that, Regulation 9.2 places an obligation on the EC. The obligation, so let's look at who that obligation is owed to. The obligation is not owed to people who have not yet delivered their nominations. The obligation is owed to nominees, which is after they have delivered and they stand nominated. It is only then that EC has an obligation to look at their forms and inform them whether or not they are valid. So after they have submitted, the law says that the Regulation 2 says that EC must now accept those ones. 9.2. It says that it must now accept those ones and then inform the people whether or not it has been properly subscribed to. What it means is that after you receive it, you must inform them. And it doesn't stop there. After informing them, there is a second obligation. So there are two obligations. The obligation to inform the nominee, and two, the obligation to give the nominee an opportunity to make amendments.
And alterations.
And alterations. That is the obligation of the EC. If you look at the High Court judgments and the arguments that the EC placed, did the EC comply with this obligation? I don't think so. I think what the EC did was to actually seek to abdicate their duty under Regulation 9.2, and then go and do something that the Constitution didn't give them the mandate to do, which is more or less constitute itself into an investigative and adjudicating body to see whether or not somebody has committed a criminal offense, and then whether or not to proceed. If you look at some of the allegations that were made, these fall in the domain of another person. But look at, for example, the one they are relying on, that a person must not subscribe for more than one person.
Yes.
If you look at the obligation on that one, it is placed on the person who does the subscription, not the candidates. So if I am the one who doesn't have an obligation, who has been given an obligation not to sign for more than one person, what it presupposes is that if I do that, I am the one who has committed, who has violated the law, not the candidates. Who, of course, the candidates, let's be reasonable. They don't share. I don't think that the candidates, after they gather their subscribers, give copies to every other person to say, you take and look through and see whether or not I have some, but that doesn't happen. So reasonably, is it expected that they would have known that some mischievous person has done that? Also look at the absurdity if we want to place if we want to put the punishment on the doorstep of the political parties. So I don't want the NDC and the NPP in the elections. So what do? I manage to subscribe to NDC and NPP. What are we saying? So what we are now saying is that then I managed to kick them out of the election because I have done what the law says that I shouldn't do. For me, it doesn't. The issue of being reasonable.
You see, the parties go fishing and shopping for subscribers.
It is true.
Politically organized party. You rely on your membership, loyal, dedicated core membership. 426 subscribers in 216 districts. The political party is incapable of relying on its loyal, dedicated core membership to cross this hurdle. That's amazing. That's good legal points you've raised, the NITU and all those things. But I want to ask questions of the parties and the candidates as well.
Exactly.
You guys are hijacking my presentation. I haven't finished.
On that issue, actually, Dr. Tukuba yesterday was arguing in the court that because the EC didn't take the time, patience, to confirm that indeed these two subscribers for Dr. Mahama had actually subscribed for another person, and therefore both of them had committed some fraud, they brought those two people to the court to show whether they are subscribed for another person. And they said no.
They issued statutory declarations to the effect that they did only for Mahama, but not for Ayariga.
Exactly.
So how did those two names get onto Ayariga's form?
So they brought those two individuals in the court for them to testify in the court whether they also did for another person or only for Mahama.
Yes.
Okay.
And that was going to pose a big trouble.
So who put those two names on Ayariga's form? Fraud is detected there.
It is.
We should cure the fraud by giving you an opportunity to go and correct it.
It is, but let's remember our jurisprudence. It is innocent until proven guilty. So it must be proven, and then who has the right or the authority to pronounce on the fraud? It's not you and I. I am not saying that candidates should be let off the hook, or that they should not do due diligence. That's not what I'm advocating.
Okay.
What I'm advocating is that what is the consequence of that? The Regulation 9 doesn't say that if the candidate has not been that diligent, then they should be disqualified. If we do that, then we are now introducing something else that
this
is,
law,
that is
we
not.
must look at this law again. Last week I said same.
That is, and
Okay.
but let me finish. When we don't like a law, the rule of law is that when we don't like a law, we go back to the body that made the law and have it amended.
I agree.
But we cannot throw the law aside because we are working with the law and we suddenly realize that is not rule of law.
Of course.
Rule of law means that if you realize there's something wrong with the law, go and amend it. But as long as you have the law, you must implement
Or
it.
go to the Supreme Court to say so.
And that's where the matter has raised.
Excellent point.
But I haven't finished. You guys are not allowing me to make my presentation.
We are ambushing.
No, because for me, what is important usually for me is the relationship between the institutions and the people. Because often, I think a lot of the time, the institutions, the sovereign is the people. But most of the time, we give power into institutions to run for the benefit of the people. And then we turn around and actually make it like the sovereignty is the people, the person we have given the power, and we kind of turn the relationship upside down. The person sitting on top here is the people. Everybody is accountable to them. So I am particularly happy that when the parties felt that their rights have been violated, they went to where they should go, which is the courts. And then the courts are competently handling the matter.
They went to the EC first.
Yes, they went to the EC first, which I think that this was an issue. I don't want to further, but the truth is, I actually think that this whole litigation could have been avoided. I think it was unnecessary. I think the instances that led us here were unnecessary. But after the where the court suits good, absolutely. I am in favor of people who push and demand. It is the only way that we can secure protection for the liberty of the individual. But just a quick point, the point about whether or not Justice Cheba could have made a ruling to cover other places. At the time he was making his ruling, there were other suits pending before his brothers. Yeah. He didn't have the benefit of those dockets. I don't think he could have just... yes, exactly. He could only deal with the matters that were before him. Yeah.
At the Supreme Court, however,
that is a different issue. So yes, I think we are all waiting for the Supreme Court decision, and I am very confident. I am very confident that the Supreme Court will uphold the law, the rights of it will, as usual, balance the scales, uphold the rights of the party. So I have no fears that
yes, I want to take you on the time.
Those you support those arguments, and some of them say the Supreme Court is the best way. Koku has suggested here also that he didn't anticipate it, but since it has happened, he supports that it should go on.
It should go on.
Now, the one claim is that the EC says, and we all know, that if I have detected an error or a mistake and it borders on crime, I don't think I have an obligation to call you to come and correct that one. Now, the Supreme Court is being invited to determine that issue.
For me, it's important.
It's important because should your opinion suffice as a conclusive judgment? It is very important because, like I said, the EC must. I also think that when you occupy certain positions or certain institutions, there's a certain attitude and approach that should go. In this case, you are an administrator, so you are trying to get everybody comply with the law. If you suspect, because remember that if you see anything, it is only your suspicion that a crime has been committed. You report that your suspicion to the relevant authority, the police. It is their mandate to investigate. If they investigate and they think that they are convinced that they also think that, yes, a crime has been committed, the law says that they should prosecute. And the Constitution says that even when you are prosecuting, if you've brought processes, the person is still innocent until a court of law determines.
I see. So we should wait for you to go through even when we have those suspicions. And then you survive to become a president. You survive to become a president. And then later we seek to now impeach you.
Okay. That's why I said some hint of legalized absurdity.
That's what I wanted Clara to be firm on. Time is still of the essence.
Just a minute. Yes.
She says that there will be an election. But
candidates, there will be an election.
Wait a moment. To have an election, there must be candidates.
Yes.
As we sit here now,
we have 4.
There are 4 candidates.
There are 4 candidates. But the commission is constrained by the processes
to
wait for the others. Because they are going to court and they are waiting. They are not printing the ballots.
Nobody has asked them to.
But the reality is that they are not. But Clara,
it's only a classical step. But it's not that they are
taking the presidential ballot. They haven't. As we sit here, they haven't.
Because if they did today and tomorrow
they say that they'll be in trouble. So we don't have a
So an election. They are dealing with the parliament.
And still going with time.
But the printing, how long is it?
Wait, please. Still going with time. Don't forget that determining the money matter is probably part of the reason why they ended up being out of time in the information.
We can move on.
It took 10 days.
Yeah.
It took 10 days after the nomination period for the money matter to be determined.
Okay, thank you. We can move on now. And the questions that are being raised also about the ballot, the pink sheet process, is this something genuine we should spend our time on, about who won the contract and whether or not they have a presence in Ghana? You raised that issue. In some 2 minutes, tell us why that should be an issue.
I think it is, given the situation where we are, because if there's a failure of delivery, again, we are in trouble.
So what's your problem? That Aero votes have won it, or that, is it what's their name? Is it back press? They should have won the contract and then you'd have been more comfortable.
Two things. The first is the scale of the pricing. That Aero vote has won it at a cost twice that of a local competitor, when we should be pushing the locals, and that the local has capacity to do it. That's the first thing. The second thing is that Aero vote is most likely to outsource this to a third party off the shores of Ghana. A process, again, over which the EC commissioner has no control. So in the event the person who's been outsourced to fails to deliver.
They have had the competence. They have done it for us previously.
Where they were before, they've collapsed. Where they were before they
No, they've shut down. They've closed shop in London, in the UK, but they are here in Ghana.
Do they have equipment in Ghana?
That's what
do they have a factory in Ghana?
The EC would have determined that before.
Yeah, but the EC has given to them as a company which bid. Did the EC inspect their facilities in Ghana that they have security?
What does the fact that they won the bid tell you?
Exactly.
That they are qualified or they are not?
Let us see their facilities. They are qualified as a company which demonstrated that they could deliver. They have a very high price. Notwithstanding that, procurement comes in, you've given it to them. Do they have capacity to print themselves and meet their obligations to us? As the EC demonstrated that they have the factory sitting there in Ghana, or it's just the company that is registered in Ghana?
If you do not know any facts to the contrary, why should that be an issue? Yes,
it's an issue to the extent that they are likely to outsource it to a third party.
Likelihood and all based on suspicion. You are not providing any facts to suggest that they cannot do this.
It is worth investigating because they set up barely 11 months ago.
Okay,
in the country.
Felix, there's evidence that suggests that the Ghanaian company, supplied a lesser price, a price which is less than, is it half of what these guys gave, and yet they won.
Well, I have no such evidence. For me, it is just another red herring.
Oh, some of us have seen some of the documentation.
But the point is that if there's any unlawful practice, I'm sure that those who are proposing that position know what to do. But you see, the point is that the EC has a track record. They have always delivered election materials for use on election day. So it does not lie in my mouth to question the ability to deliver on that front. And to the extent that those making this allegation are even unable to definitively say that the people who have been contracted do not have the capacity, i.e. they don't have local presence to be able to do the job. It's enough indication that they are only speculating.
What do you think is Yao's fears? What do you think?
I think that the MPP itself goes around fishing for reasons why the credibility of the EC should be doubted. That is what informs some of the things they are doing. You see, the way that they have behaved in the past makes even legitimate claims that they make now difficult to accept. Because in the past, in the past, they have gone on tangents that have been proven to completely false. They have, for instance, alleged before that there are 760,000 foreigners on our election roll, only for us to find out that they don't. No. You stated at a press conference, your vice presidential candidate stated at Alisa that you had evidence of 760,000 foreigners on our register, and that you had presented just 10%. In due course, you will furnish us with 90%. You didn't do that.
He said he had found 76,000.
He said it constituted 10%.
Yes,
but what does it mean? No.
But that's a matter of fact. He said that correctly.
He said 760,000.
And that it is.
He said 76,000, and that is potentially only 10% of what.
But when you say that,
and the EC refused to even deal with that.
No.
The EC refused to deal with it.
You actually told the EC later that you were no longer interested in the 90%.
Because the EC refused to deal with the 10%.
Sorry.
Let's just put it on record.
Please.
When you say that you have 76,000 names, that constitutes 10% of the evidence. It means that you have 7,000. It means directly. It means directly that you are
not helping. You are not helping.
You see,
please,
when you say you have 10% of evidence, which amounts to 76,000, it means you have 760 in all. That's what you said. But
thank you.
The point I'm making is
let me hear quickly.
These are red herrings that we refuse to deal with.
Yes.
You said you were no longer interested.
You've heard of those allegations flying all over the place. Sorry, gentlemen, stop that. Flying all over the place, and EC boss was asked that question by BBC's Akwesi Sapong, and she said, look, the company has folded up in the UK. They are here in Ghana. They've set up. We understand they set up some 11 months ago, and they've bidded and they've won. And she is happy that in fact they're going to give jobs to Ghanaian people. So what's the big deal about all of this?
Well, did they win the contract? I mean, is it error vote?
Yes, error vote.
In accordance with the procurement laws of this country?
That's the presumption.
Yes, so until we have something contrary to that, we proceed on that assumption that they did. The Public Procurement Authority was involved in all this process in accordance with law.
One of the criteria for winning the bid is that you are you give the lowest price, and the documents that are being shown now shows that back press had the lowest price.
Not
the last time I
said
checked,
one of them.
Yes, so
there are three things normally.
Because
technical.
price consideration
is one of them.
It's not the only.
Exactly.
We all know
the least price is one of the
Yes, but it
only
is
one.
not the only.
Right.
It takes my mind back, of course, that will come from a reverse angle, to the Vodafone divestiture saga. And we had to fight over that issue. That the mere fact that somebody came with a bigger figure did not mean that a person should win. You know that.
Yeah.
Right.
Yes, so let me proceed. Now, there are issues about who would print it and where it to be printed.
Right.
And the question of local companies. Those locals, 2012, one of them printed. Did he print here? He won the contract, but he subcontracted it. And it was printed outside.
Okay.
Is that not the same thing that will happen? Assuming a
Assuming that
local
we don't
one.
have local presence.
Yes.
So your points are
time
founded.
of this. So
Right.
me, my point is always on time.
Sorry, guys.
As for the election,
Guys,
it's
okay,
about
we've heard
time.
you. We've heard you. Thank you. Just a small bit. There are too many issues surrounding the elections. We obviously cannot discuss all of them. The issue about the accreditation and the concerns about the journalists that they are supposed to pay for the process.
Yes, and I think this is not the first time. One of the by-elections, journalists were made. You're actually paying for the tag.
Right.
Yeah.
You know, I would have wished it wasn't done that way. But I told we are so many, so that's where the mind is coming from.
Okay.
That they would, but I would, from a journalistic point of view, I think they should give it to us.
Okay, sorry.
Very quick one.
Let's
Okay,
discuss the election.
very quick information on the tag thing.
It should be free of
Very quick
charge.
information on the tag thing.
I think they should take that
Samson, I've
burden.
heard the EC say
The EC should take the burden. I
Right.
can understand
no,
where they are coming from.
Okay.
They have
So-
actually
so-
said that
yeah.
there are financial implications. In the past,
I know.
donors have helped them to foot that bill, but those donors are not supported now. So they are left with no
Sorry,
option.
there's a group of journalists
Yes,
that
yes.
issued a statement saying that the money the EC is using in the court litigation, they should use that to claim against them. We'll
So
take
they
a
should
break.
defend themselves
When
now.
we return, Martin Amidu says he has insider information and he's actually put them before the court. He says, if you will not cross-examine Woyome, allow me to do that job. He says it is the president that ordered the Attorney General not to go ahead in pursuing Woyome because Woyome had threatened to sing like a bird if he's put under cross-examination in the Supreme Court. We'll be back and look at that issue and the government's pledge to fight corruption.